This is part B of the KHOODEELAARTV television channel being broadcast on the internet under the banner of BABY Angel Geronimo Editions. This one is continuing with the investigation into the reports on Tata Steel. Now, Tata Steel has been subsidized by the United Kingdom for decades under one pretext or another. And the subsidization or subsidizing of Tata Steel by the British economy has been paraded as in sold, promoted, justified in a false slogan, which is that the subsidizing of Tata Steel has secured jobs for British workers. This is the front page of the weekend, Saturday and Sunday edition of the CPGB, the Communist Party of Great Britain, Morning Star. And their piece is bylined by David Nicholson, Wales reporter. Steelworkers vowed to fight for their jobs and industry yesterday after the British government announced a 500 million investment package in Tata Steel that could cost 3,000 jobs at the company's Port Talbot Steelworks. Now, this is going on under one pretext or another, under one slogan or another, for a very long time. The Tata Steel being subsidized, and Tata Steel has always been featuring in the news as being in receipt of millions, hundreds of millions of pounds of the British, from the British government. And it seems that Tata Steel never gets out of this subsidizing relationship and in an operation on its own economic viability and capacity. The information in the Communist Morning Star, which is Morning Star, and the reason why we call it Morning Scar is because of the distortion of the objective news, facts, and information that it contains. So here it is saying 500 million Tata investment package could cost 3,000 jobs. Story tax on steel workers. Now, it is not possible to see any evidence ever of the Tories not turning their back on steel workers at all. And this piece is completely ignorant because it doesn't give a cohesive timeline as to how many times Tata Steel has been subsidized in the name of the UK economy and in the name of rescuing or securing jobs that would otherwise be lost. Main paragraph, but the rest of it contains a reference to Stephen Kinnock. Stephen Kinnock is described as an Ebaraban, Labour MP Stephen Kinnock saying, the deliberate exclusion of the steel workers unions from the whole process is deeply disappointing. What he's saying is that the deal between the Sunak government and Tata Steel, about Tata Steel being given £500 million subsidy, was witnessed from a kind of distance before the camera. So Stephen Kinnock is saying it's disappointing that the unions have been left out, excluded. Why should he be disappointed? This has been the norm for decades. This is the second item connected with the kind of fraud relating to the operation of Indian origin court business based in the UK. This piece on the Times on Thursday in the legal section called The Brief. Byline 2, the Times says legal editor Jonathan Ames The piece about the suspended solicitor called PRAGNESH Modhiwadia. Yes, I've been looking for it and it is hiding from capture, if you like, by the camera. This is the piece on the Times, page 55 of the Times. Thursday, the 14th of September. From lavish bash to fraud claims. And it's a piece by Jonathan Ames, Ames, the Times' legal editor. It doesn't say that there, but that's the. This is the picture. If we can get this in front of the camera, just about. This is the picture of this is the picture. This is very delicately putting before the camera. This is the picture of Pragnesh Modhiwadia. Pragnesh Modhiwadia, who is the main driver behind the corrupt legal business. And this item that the Times' current legal editor has written contains quite serious allegation about the incompetence on the part of the Law Society's Solicitors Regulation Authority. So we read this in the past, and just to get this in perspective, this is the continuation of the Baby Angel Geronimo essay. And the Baby Angel Geronimo essay so far has been kind of focusing on the corruption and the criminality that is the English legal system, judicial system. And the basis of the assertion that it is corrupt judicial system is the actual contents of the ruling dated the 29th of July 2021, made by the so-called High Court Judge Griffiths in the case that Griffiths apparently heard. It's an appeal by Helen MacDonald, Baby Angel Geronimo's mum, represented by Catherine McGahey, instructed by the solicitors firm called Oliphant Solicitors. We have extensively diagnosed the whole thing, and we have found that Catherine McGahey did not refer to any of the requirements under international law that the United Kingdom government was required to comply with. The treaties, the declarations, the conventions, the statements that the United Kingdom is actively signed up to require basic, express, explicit compliance by the government. And Catherine McGahey did not raise any of those statements, conventions, agreements, treaties, nor did she raise any instance of the breaches of the requirements by the government, that is the DEFRA. Or the party that responded to Helen Macdonald's appeal in that particular proceeding. And the other thing we have been saying basically is that Griffiths seems to allow the UK government, that is in the form of the DEFRA, 100% impunity, 100% impunity from accountability, which means that whatever the evidence, whatever the proof, whatever the actual scientific evidence about the state of health, which is the issue, the state of health of baby angel Geronimo, the outcome, the actual statement, the state can be ignored, disregarded. The evidence of that can be disregarded by the Secretary of State, whoever the Secretary of State concerned may be. And in this case, the Secretary of State has been George Injustice Eustace. But of course, it's not Secretary of State Injustice Eustace. It is the Chief Vet, Christine Middlemiss. Christian Middlemiss. But whatever the internal distribution of responsibility or part or participation in making the murderous decision, the actual opinion of the judge, Griffiths, is that it doesn't matter what the facts are. The Secretary of State is immune, and the Secretary of State can be allowed and is allowed to disregard the evidence. So even if there are a million items of evidence showing that baby angel Geronimo is perfectly healthy, showing that baby angel Geronimo was never tested, because the test that they staged in 2017 or staged after baby angel Geronimo's arrival in the United Kingdom in 2017 from New Zealand, the tests were rigged in a way that was physically intended to produce the wrong, false reading on the state of baby angel Geronimo's health. It was a rigged test. So therefore, the only way to establish the truth once and for all was to hold an independent scientific test, independent and away from the control of DEFRA and their agencies, so that baby angel Geronimo's health could be examined independently. Now, this went on, this debate, this argument, this call by Helen MacDonald to allow her to hold an independent test to determine the actual status of any infection in baby angel Geronimo's body. This has been refused, and the refusal has not been based on science. The refusal has not been based on material evidence. The refusal has been based on DEFRA hiding behind an excuse that the Secretary of State is entitled to ignore facts. It's a multiple contradiction, multiple unscientific illegality and criminality. So, based on that, if this diagnostic statement that I've just updated and made, if this is translated into material stages of brand new, absolutely independent test on baby angel Geronimo, then it is impossible to find baby angel Geronimo in any way connected with any infection whatsoever. And DEFRA knows that. And Griffiths knew that when he repeated the servile statement that the Secretary of State is entitled to ignore the evidence. It makes a mockery of the concept of testing. Opinion on the part of independent observers, independent scientific was to let an independent test be carried out on baby angel Geronimo. And they don't want that because they know that baby angel Geronimo is fit and is not infected in any way. So, how to hide that corruption and criminality? Well, easy, because a criminal complicit with the government, like Griffiths, is not going to raise any questions. He is going to let the lying agenda of the Secretary of State prevail, which is his ruling so called, dated the 29th of July 2021, proceeds to say. And therefore, so the no matter how many times a test is carried out, as it is claimed by the DEFRA, in the time since baby angel Geronimo arrived from New Zealand in the United Kingdom, the test has been rigged already. And the rigging has been done by physically intervening, making physical intervention and interference with the biology of baby angel Geronimo. So that the direct result of the interference, as predicted by the interferers, was a reading that said that baby angel Geronimo was testing positive, which is absolute lie. Baby angel Geronimo never tested positive, never can test positive. So we shall be talking about the fraud, the corruption of the law, in the law, through the law, via the law. And here is the piece by Jonathan Ames or Ames, from lavish bash to fraud claims. And the whole thing is full of corruption by the solicitors regulation authority, because they were sent questions by the Times in order to clarify what they were doing by way of their duty to make sure that they were stopping a criminal like Pragnesh from setting up business when he was not fit to set up business, operate a business as a lawyer. He is suspended. His certificate has been removed from him. And the fact that he got through various stages and set up the business in the first place shows that those various stages should have been marked by intervention by the regulator, which is SRU. Sorry, Solicitors Regulation Authority, SRA. The fact that the SRA was not active is proven in the fact that Pragnesh has got through various stages. So if you extrapolate that about the legal environment, you can see how the various licensed law traders appearing in various capacities in a court are violating objective legality, objective requirements of evidence. This is Pragnesh, the picture of Pragnesh there. That is Pragnesh. And Pragnesh, his second name is Pragnesh Modhiwadia. Pragnesh Modhiwadia was allowed to set up business, and then he was able to get involved in fraud, which is what the whole purpose of setting up the business was to begin with. And Ames says, in court this week, that is last week, lawyers for Modhiwadia said that about 64 million pounds had been taken from Axiome's client account and used in part to buy the two law firms and to purchase 6 properties and for construction work on 7 others. The regulator declined, that is, the Solicitors Regulation Authority declined in response to the questions from the Times, which is not mentioned here. The declined who is not explained, but I'm explaining. The regulator, that is SRA, declined the Times's kind of approach and request for comment. So the SRA declined to comment on the details of Pragnesh Modhwadia's criminality. But the SRA noted that using client money for a firm's own purposes is not allowed under the accounts rule. God, I mean, what a devastating, rough, rigorous regime that is. It's ridiculous. Every year, the Solicitors Regulation Authority ignores literally thousands of items of evidence that it is sent or is brought by complainants against solicitors. So our view is that if the SRA acted in the way that it should have acted, then hundreds of thousands of criminal behavior, acts by firms of solicitors could have been prevented. But it doesn't act at all. So the solicitors are lying, the barristers are lying, and the judges are lying. So who would hold them to account? Baby Angel Geronimo can only witness the criminals at work. Baby Angel Geronimo cannot issue a directive except to say to the criminals that they have lied and they are being recorded over the lies that they have perpetrated. And if you extrapolate again the same lack of principle in terms of auditing the behavior of the UK government, say covering the latest multi-million pound back, the multi-billion pound back kind of payment that has been made to Tata Steel, and you see that there is no regulation and no presence of any lawyer or legally charged as to whether the deal between the government and Tata Steel, latest deal, has been consistent with the duties to safeguard the resources that belong to the people of the United Kingdom. And likewise, the German Republic. The district Judge Layton capitulated to and colluded with DEFRA, as did Griffiths. When the particular individuals that are responsible for the deficit, for the shortfall, the crisis that required the investment of 500 million pounds by the UK public, why are those people who are responsible for the collapse of sustainability in Tata Steel's operation, why are they not being held to account? We shall be bringing an end to this particular part again, and we shall continue the Baby Angel Geronimo essay in the later parts whenever we publish